how much, back to the FERPA note for a second, how much information should be shared with an instructional assistant or bus aide or somebody helping in that regard? Because of the provision under FERPA that says we're supposed to only share with those that have legitimate educational interest. You know, I would say that a instructional assistant or a bus aide does fit under the legitimate educational interest. But it may not necessarily be that you share the entire IEP, for example, but maybe that you share, an abridged version or a summary, or at least information about the student's disability and behavior plan for the IA to be able to do their job, for the bus aide or driver to be able to do their job. So, now if the bus aide or the IA starts asking for all sorts of documentation about the student that really isn't, within the scope of what their job responsibilities are, you, as an administrator or a special education department, can deny that. But it is probably under the umbrella of legitimate educational interest to share some information about the student. Secondly, tell me what that form was called.
Student at a glance.
Student at a glance. I don't know if all of you have that and it follows the student. I think we've talked about this before a couple times when I've been here about how to sort of track. We may even come back to this when we refresh a little bit about bullying later. But student at a glance form, if used, would be considered an educational record. I don't know if we get back to the whole discussion whether it's a permanent record, but it is an educational record. And to the extent that a parent makes an educational records request, you're going to have to give them the student at a glance. So the caution on that would be, I think, take back to your buildings a reminder about what you put in those student at a glance. I have seen, Jessica has, that we sometimes put, yeah, this is a crazy mom, right? And then that student at a glance document has to be given over to the crazy mom, which isn't going to help matters.
Challenging. Parents are challenging. That's our keyword.
All right, so those were a couple of comments during the break. And as we started today, I intended on doing this. If you wouldn't mind, if you make this 30 seconds very, very quick. But Jessica and I think both have worked with you or talked to you on the phone. Maybe very, very briefly, remind me names and where building you are, because I know we have a couple of new people. Sherry, you want to start? Get it going?
Sure. Sherry Great, Superintendent.
Kim Zachary, Executive Secretary.
Ryan Holy, Middle School Principal.
Chris Baldwin, HR Director. Bill Knox, Assistant Principal, High School.
Rob Hedges, Principal, Shamrock Springs.
Stacy McGuire, High School Principal.
Lynn Shumwell, Central Office, Data and Assessment.
Carmen Carnes, Assistant Principal, Westfield Intermediate.
Mike McKinney, Assistant Principal at Westfield Intermediate.
Annette Patchett, Principal Intermediate. Jane Hitch, Assistant Principal at Trace.
Kristen Parisi, Assistant Principal, Washington Woods.
Dan Breda, Director of Technology.
Nick Verhoff, Central Office.
Marcy Dorado, Assistant Principal at Monon Trail.
Mike Hall, Principal at Monon Trail.
Andy Hilton, Principal at Cary Ridge.
Libby Vaughn, Assistant Principal at Maplewood.
All right, thank you. Here we go into the special education section. And again, we'll probably advance these slides as we get going because this could be longer than we need it to be. IDEA, the Individuals with Disabilities Education Act, also a law that is probably up in the next few years, hopefully the next year or two, for reauthorization at the federal level. And we know, just a very brief history, here's kind of the steps we've taken. It used to be called the Education for All Handicapped Children Act. It became the Individuals with Disabilities Education Act. And then in 2004, it was revamped and some changes were made. So this is our primary federal law that is implemented at the state level called Article 7. And you've heard of it. The 6 pillars of the IDEA. Again, I'm not trained to be a speed talker, but I will probably talk a little faster to get us to the cases we want to talk about. These are the 6 pillars or foundations: having the IEP, having a free and appropriate public education. Sometimes people like us to break down the acronyms because Jessica and I use these every day, but not all of you do. least restrictive environment, meaning we want them to be included as much as possible in a general education environment. Appropriate evaluations for student and parent-teacher participation and procedural safeguards. So, to get us into this roadmap, let's talk a little bit about the free and appropriate public education. I'll ask Jessica to just briefly touch on the historic landmark case called Raleigh to set the foundation for what I'm going to talk about with a United States Supreme Court case here in just a second.
So our keyword that will guide us throughout all of this is FAPE, free and appropriate public education, and essentially that's the standard or level of educational benefit that has to be afforded to children with disabilities. Now, IDEA will define that from a procedural level. Basically, IDEA says that if you give services that are free, meet state standards, include appropriate education for that level, and are provided in conformity with an IEP, then you provide FAPE. But essentially, that's just the procedure you have to walk through. So our key case that you probably remember being thrown around a little bit while you were getting your degree is Raleigh. That's a 1982 case, and what this essentially said was, thanks IDEA, thanks the law for telling us what procedure we have to follow, but Raleigh is really what's going to define FAPE from a substantive level. And what they said was, this is the Supreme Court case that says, a school district will provide FAPE to a student with a disability if it develops the IEP in accordance with IDEA procedures. So if we follow those procedures we just talked about, and also if the IEP is reasonably calculated to enable the child to receive educational benefits. That's our key phrase that we get from Raleigh, is reasonably calculated to enable the child to receive educational benefits. The question then becomes, what level of benefits? So, if the child gets some educational benefit, is what Raleigh tells us, that benefit has to be sufficient to provide them with access to education that is meaningful. I've been doing this for a while and I have no idea what meaningful education really means, to be honest. But that's why the Supreme Court got re-involved this year. We're looking at Raleigh one more time. We've had 35 years under that Raleigh standard. The Supreme Court has not looked at what FAPE means for 35 years. And in doing so, that means that each court of appeals, there's 11 courts of appeals throughout the country, kind of developed its own standard for what that meant. For our particular circuit, the Seventh Circuit, we fall somewhere to the left of this spectrum. What you see here is a spectrum of the level of educational benefits that different courts throughout the country were operating under prior to this year. So some courts were saying, look, if an IEP gives any educational benefit whatsoever, if it's more than a de minimis standard, more than minimal, then you've provided FAPE. Other courts kind of moved to the right and said, well, the level has to be more than that in order to provide FAPE. You have to give some level of educational benefits. You have to give a meaningful level of educational benefits. And so what we were really worried about when the Supreme Court took up this new case that we're going to talk about is we had the idea that the Supreme Court might move us dramatically to the right. You know, all the way to the right off this slide would be maximizing educational benefits for students with disabilities. But what we were all the way on the left end of this spectrum, we're thinking that our circuit may have been overturned. And so what we found out was, through Andrew F. case in the Supreme Court, is that, I'm going to go back on the slide, is that they actually moved us a little bit to the right of the spectrum, but not near as far as we feared they might.
Okay. So, Andrew is going to talk about injury. I just came up with that a second ago, so I understand that it failed. All right, let me go back just a couple slides. When Jess was talking about the procedural piece, please keep in mind as we talk about NDREF, the meeting the state standards piece. There's a guidance piece that's coming from the Indiana Department of Education through ESSA and through other guidance that I want to emphasize, especially as general education people, but also, of course, with special education, about meeting the state standards and what it's going to mean in the context of this United States Supreme Court case. And, you know, many of your special education folks may not, know about this case. It just came out this spring in terms of the decision. So, you know, having a slight different opinion from the highest court in the United States will probably want to have some dialogue about that. So let's put yourself in this situation. You have a student in your building with attention deficit disorder and autism, all right? The parents believed that the 4th grade IEP had produced no meaningful educational progress, and they reject the proposed 5th grade IEP because it was largely unchanged from the 4th grade. One of the bigger takeaways, practical takeaways that you can encourage your special education folks to do, make sure that the IEPs from year to year don't look exactly the same. That's probably the biggest argument that we see from parents, is that they'll say, well, this 4th grade IEP looks exactly like the 5th grade IEP. And we really didn't see any progress, we didn't see any changes. So at least refreshing the language, refreshing the goals, refreshing the services, making them appear at least a little bit different is big. The parents withdrew the student and placed the student in a private school specializing in children with autism. So we've had a couple of these situations, I think even in Westfield this past school year. In fact, I mentioned we have one at another one of our clients that left Westfield and went to another school district and is school shopping because of a situation much like this. So, the parent alleges that the school failed to provide the free and appropriate public education, is suing essentially for money to pay for private school. If you go back to Jess's sliding scale, their argument is you didn't provide the right side here. You didn't provide a meaningful educational benefit. And, you know, we're arguing, or the school then is arguing, well, we're not required under Raleigh to provide meaningful, we're required to provide some educational benefit. So that's what the court was looking at. The issue is basically, how do you measure what is reasonably calculated educational benefit? How do you determine the litmus test, the highlight, the bright line test? So March 22nd, 2017, we know this case came out of the 10th Circuit, Colorado, and very similar to us, they have a standard of some educational benefit. All right, now that you're into the NDREF case, is this hitting home? If you can think about a student like this, maybe it's behaviors, maybe it's reading progress, or whatever the case may be, but here are some quotes that came from the United States Supreme Court justices when they were debating whether to change the standard. Justice Breyer, I foresee taking the money that ought to go to children and spending it on lawsuits and all sorts of things. That's what's bothering me. Chief Justice Roberts, it says some benefit. The law says under Raleigh you're supposed to provide some benefit. But he was saying to the attorney arguing the case, you're reading it as saying some benefit. And the other side is reading it as saying some benefit. So this was meant to be a light moment in the argument that how do you really know what some benefit should be interpreted as? Significant, meaningful, whatever, it's more than simply de minimis. And I think we've known that in Indiana, and we've known that in Illinois and our surrounding states, that it shouldn't be just a minimal level of progress. It should be individualized, it should be a whole package, that we should be attempting, ideally, to make the student, or help the special education student make progress. So, let's go to the unanimous decision. To meet its substantive requirement, a school must offer an IEP reasonably calculated to enable a child to make progress in light of the child's circumstances. This last little phrase, in light of the child's circumstances, reminds us, again, I think Jessica's point as we introduced this case and what it means for you, doesn't dramatically shift things, but reminds us maybe to go back and remind our special education folks, sharpen our pencils, sit up and be diligent about, in light of each child's circumstances, we're supposed to help them make progress. Some benefit of Rally is not measured in absolute terms, but in relative terms. Again, appropriate in their circumstances. I want to stop for a second, and again, I've appreciated this morning our dialogue, your interaction. This slide is probably the one that I would spend the most time on if we're going to pause for a moment. So from the decision, when a child can't be fully integrated into the general ed classroom, this is a quote, the IEP need not aim for grade level advancement, but his educational program must be appropriately ambitious. So we put this in red and bold and highlight for you. The court is encouraging us to be appropriately ambitious in light of their circumstances. Just as advancement from grade to grade is appropriately ambitious for most children, the goals may differ, but every child should have a chance to meet challenging objectives. Now, for us, again, in interpreting what that means to the Rally decision, the 1982 decision, it doesn't dramatically change things. I think there's been lots of news articles and lots of summaries of what this case means. Again, to us in our office, it means sit up, think about it, pay attention to it, encourage your special education staff not just to have cookie cutter copy and paste IEPs, but be ambitious in light of the child's individual circumstances. That's what it means. It doesn't dramatically shift fate and what the benefit level is. We're still supposed to help a child make some progress educationally. But for us in the 7th Circuit, meaning the court where we're at in Indiana, we were already doing this. All right? It's just the fact that we've got to remind ourselves to do it. Now, in some of this language, though, the IEP need not aim for grade level advancement. That's the piece I meant on the state standards. The guidance that we've received from the Indiana Department of Education and the special education director there, Dr. Pam Wright, they're telling us that they do want to see IEPs that at least reflect the state standards for that particular student and what the state standards should be at their grade level. So let me try to go back and illustrate this. So if we've got, for example, let's use this kid. He's going into 5th grade. If we've got a 5th grade student, but that student is reading at the 3rd grade level, the goals on the IEP, what is ambitious for that student? Well, if they're in 5th grade and they're only reading at the 3rd grade level, what would be an ambitious goal in light of that child's circumstances for one school year? 3rd grade reading level. Anybody? Maybe go to the 4th grade, right? So I agree, and I think in their goals of their IEP, we would say we want to advance the student from 3rd grade reading level to 4th grade reading level, measuring this reading progress. And that's a horrible goal, so don't repeat that. But my point is that in light of their circumstances, if they're at 3rd grade level, we want to move them to 4th grade level. But on top of that, in Indiana IEP system, in the software system, there is a drop down on state standards, separate and apart from the goal. And according to Indiana Department of Education, they want to see the 5th grade state standard should be mentioned there. Because their point is with ESSA, with Andrew F., everything else thrown into a mixing bowl here, they want to know, yes, that student is in 5th grade, so what is the state standard they're supposed to be working towards? And then let's say they go to 6th grade, or they go to 7th grade, they make their way to high school. If they're below grade level at their functioning ability, the encouragement is you should still be putting in the state standards for what grade level they're attending. That causes a bit of confusion, I think, so I want to take a moment and clarify that and see if you have questions about that. Because I did when I first, because I was so used to programming in an IEP for where they were performing. And the clarification I also give there, we don't have to aim for grade level advancement, putting them at their grade. We should go back to the goal. There's a difference between putting the goal in the IEP, where their their present levels of performance, where they're performing, and saying, okay, they're at 3rd grade level, we want to get them to 4th grade level. And then there's a difference between that and then the state standard. The state standard is, well, they're attending 5th grade, so we should put in there, what is the 5th grade standard? I think the rationale, not my rationale, but the Department of Education rationale is they want to continue kids on diploma track, working towards graduation, and they don't want to not put in there the state standard. That's what I've heard. Questions about that and how it impacts what I just said about Andrew F.
So no matter what, on the drop down, they're using their current grade level standards.
Yes.
But the goal is actually at their
The
present.
goal can be at their functioning level, but the state standard should still be noted for, and we looked at this I looked at it a couple weeks ago. I got into a hypothetical student on the NIP. Kristen, you were shaking your head. That is a separate click drop down in the state standards that's separate from the goal.
Well, it's a part of the goal. It's part of the goal sheet.
But I think you hit that actually first.
It's all on the same sheet. So you're putting in present levels, and then you drop down the goal, or the standards you tie it to, and then you put your own objectives in that'll tie to your measurable goal. It's all on the same page, the same.
Does it prompt you to put in the state standard first before you go to putting in the goal though? Okay. Well, go ahead.
So I think the difference in my head is that the goal, because we always talk about that the goal has to be, the goal should be a non-grade level goal, because if it was a grade level goal, then they wouldn't need the IEP. So the difference is the goal can be where the child is and should be where the child is functioning. The standard is just, if they didn't have the IEP, this is the standard that would link with that goal. Or this is where we would want them to be. That's kind of, I think,
Yes,
in my head, it's not, the standard isn't the goal.
Correct. And that's another way of saying something I was going to comment on. You are not, the measuring stick for making progress is not the state standard. The measuring stick is your goal. Does that make sense? Does that help? So when we're talking about being ambitious, the goals, every child should have a chance to meet challenging objectives. They want to see what the state standard is, but we're going to have to retrain the hearing officers, the judges, to understand that measuring stick is not the state standard, because if we've got a student dramatically underperforming, that's not what we should be looking at to see if we make progress. It's the goal. Questions, concerns?
I think the larger point too here is IDOE is focusing, and the Every Student Succeeds Act is focusing on state standards because they are seeing kids at a very young age taken off diploma track. And that's really starting to throw a red flag. If you're going to take a kid, especially an elementary school level kid, off of diploma track, we need excellent data demonstrating that a diploma is never going to be in the cards. The emphasis on thinking about state standards, thinking about grade levels, thinking about making appropriately ambitious IEPs is, I believe, very much a reflection of fear of seeing too many kids taken off the diploma track at a young age and then they never get back on. And we're cutting kids out of the game before they have a chance to demonstrate that they may actually be able to achieve that. So just a larger thing to keep in mind with NRF as well.
Okay, I'm gonna wrap up NRF unless you have questions, and we can talk more. The decision confirms the court's trust in the schools that we craft IEPs in a prospective judgment. So it meaning going forward, if we're sitting here today, all of us in this room, programming for Andrew Manna's IEP, we're looking forward, not retroactively. So no Monday morning quarterbacking, and courts remind us that they don't substitute their own judgment for ours. So those are positives. There was a lot of hand-wringing and concern about what this decision would do, but at the end of the day, I think we feel much better about where it ended up. Reflects, I think I said some of this, need to show progress, otherwise it defeats the whole purpose. We do need to show some progress, but again, appropriate in light of the child's circumstances. This is not a huge legal shift by any means. And finally, I think I already gave you some of these takeaways to take back. These are points I would highlight for you. Encourage your staff not to recycle IEP, change the goals, update them, make sure it's ambitious and unique for that student going into the school year. Okay? All right, now that leads us to another spring United States Supreme Court decision that we want to highlight for you.
Okay, so I'm going to tell you how you can get sued for $1 million over a dog. All right, so first of all, I just want to start with, of course, we've been talking about IDEA, and that is one of the main laws that protects individuals with disabilities in our schools. But that really just protects students. It's not about adults, it's not about visitors to our school. It's about whether or not we provide FAPE to a student. And one of the fun things about IDEA is that it forces parents who have a dispute to file a local level hearing. That's our due process hearings or our IDOE complaints, our IDOE requests for mediation. They have to start at a local level and they have to talk to us first. For everybody that walks into any of our buildings, because as a public school, we're a public governmental agency. If a visitor, if a parent, if a teacher, if a student walks into our building, they're protected by the Americans with Disabilities Act and Section 504. And those are essentially discrimination laws. So basically what those protect are any individuals with disabilities to have equal access to all of our facilities, equal access to our programs, that we won't discriminate against them based on their disability. This is the same type of law that allows somebody with a seeing eye dog to walk into the post office as well. It just happens to apply to schools equally. For those two laws, you don't have to start at a local level. You can immediately file a civil lawsuit in federal court. And most importantly, for people who are filing those lawsuits, they can go for the money. Under IDEA, they can only go for denial of FAPE. So they can go for educational type remedies, like I want more tutoring for my kid, I want you to change his IEP, things like that. But if I'm going to sue you under the ADA or under Section 504, I'm going to go for money. And this is what we're starting to see a massive rise in litigation in schools under these two laws. What we've talked about already is that IDEA requires parents, or the plaintiffs essentially, to exhaust all administrative remedies. That means to file a local level hearing before they go to civil court and file for monetary damages. This is the statute under IDEA that requires that. But that's all going to change with the Supreme Court. This was a case that came up in the spring, and it worked its way all the way up to the Supreme Court. Essentially what happened was a little girl was going to enroll in kindergarten. When she went to enroll in kindergarten, she had cerebral palsy, and they got an IEP for her. They were set to go, and they gave her a one-on-one IA with a bunch of other things as well. The parents came back and said, we have a service dog that is trained to help our little girl. Wonder, the service dog. Wonder was trained to perform things like retrieving dropped items, balancing when using a walker, he helped the little girl balance, opening and closing doors. The dog could turn off and on lights. The dog could help take her coat and essentially, I guess, help her to her desk. And the dog could help transfer her to and from the toilet. This makes my dog look really bad, but this is what this dog was trained to do. So they said, we want the dog in the school. The school said, you know what, really, your one-on-one IA does all of those things. We're already giving you a one-on-one who will help transfer you back and forth to the toilet. The one-on-one is going to help you, retrieve dropped items, things like that. So you're getting everything you need. You don't really need the dog here. So the parents pulled her out of school, filed an OCR complaint. Anyone who's been through an OCR complaint frequently, I'm looking at Dan because we're going through one right now, knows how time consuming those can be and stressful those can be. OCR comes back and says, you know what, we agree with the parents. Under the Americans with Disabilities Act, this child should have access to the school with their service animal. It's an access issue. It's not necessarily a faith issue. So the school says, okay, we'll let you come back with the dog. That's fine. And when the parents came back, they said, you know, I feel like you don't really like us anymore. And so we're just going to go somewhere else, but I'm still going to sue you anyway. This is a kid that's never set foot in the school district. And the school district has now had an OCR complaint and investigation, and now they're in federal court because they have not permitted the service dog to be a part of the child's education. So it goes all the way up to the Supreme Court, and the issue is essentially, did the family have to go through IDEA before they filed under the Americans with Disabilities Act? The school says, you know what, you should have filed a special ed due process. This was really through the special ed process. You asked for it at a case conference. We should have gone through an administrative level here. The parents came back and said, no, we sued you under the Americans with Disabilities Act. We want money, and we don't want to come back to your school. We've moved on to a different school, so you can't really provide us any sort of educational remedy, because we don't want it. The United States kind of stood with the parents and said, you know what, the school agreed to allow the dog, but the parents already moved on to a different school. So there's really no educational remedy here. The parents have moved on, and we're okay with them just suing you for money because you didn't allow the dog in the school. The Supreme Court agreed with the parents. And so this worked its way all the way up to the Supreme Court, and the Supreme Court said two things that are important. Number one, that exhaustion, which is that requirement to file a due process hearing, start at the local level, that only applies where you seek relief for a denial of faith. So the only time we're going to make parents go through that local due process level is when they want something educational, when they're telling you that you denied free and appropriate public education. And what we're going to do is we're going to look to the substance of the complaint, or what they said was the gravamen of the complaint, which is a fun new legal term we get to throw around our office now all the time, to understand whether they really are seeking faith or they're really seeking money. They gave two hypothetical questions that kind of help us figure this out. The first hypothetical question is, could the plaintiff have brought essentially the exact same claim if the conduct had occurred at a public facility that wasn't a school? If there was a public theater or a library, and you could argue the exact same thing against a library that you did against the school, then you're really not talking about education, you're talking about access, you're talking about discrimination. You're talking about something that applies to all public places. And if they are talking about that, then you're not really talking about IDEA. You're talking more about the ADA and access. The other thing they asked for a hypothetical that helps us is, could any adult at the school, like a visitor or a teacher, have filed the exact same issue too? Because as you'll remember, IDEA only covers students. We're only talking about faith with students. So if one of our teachers could have filed this exact same complaint, well then the teacher's talking about the ADA and access and discrimination. They're not talking about educational remedy. So if those two hypothetical questions could apply, then they probably are okay to sue you for monetary damages in federal court right away. The place where we're going to see this the most is with service animals. We're going to see it with discrimination. We're going to see it with equal access. Things like wheelchair ramps, things like bringing service animals into the school building, things that have to do with giving people, anybody with disabilities, access to our facilities, access to our programs. That's where we're going to start to see this litigation on the rise, because that's where they're going to completely skip over IDEA and say, I really want to sue you under the ADA, and by the way, under the ADA, I want a couple of $1 million for what you've done. This is where this could end up going, which is very scary for us in our office. This was a case that happened before the Supreme Court case. And essentially what the parents did was they sued the school under IDEA first. And they went through the IDEA process. They said, I have a special education issue. I'm going to file a due process hearing. I'm going to go through the due process. But after I did all of that, it seems like you retaliated against me. It seems like you treated my student differently because I happened to exercise my rights as a parent of a child with a disability. And that is discrimination. That is an equal access issue. That doesn't have to do with faith anymore. So after they filed all the special ed stuff, then they came back and filed again under the ADA and said, you discriminated against us. That's an ADA claim. I want money. Because now what you've done is you treated my kid differently based under their rights under the ADA. Supreme Court basically said, now that we've discussed the Fry case, why don't you go back and rehear this again? But this is a pretty scary proposition for us because it essentially means that when you have parents who file the special ed process, go through the special ed process, they might be able to turn right back around if they feel discriminated against for going through the special ed process and file for monetary damages under federal court. So we're really watching this super closely, but I think the takeaways essentially are, if you have a request for a service animal, if you have a request for a wheelchair ramp or a special accommodation in some way, shape, or form, be extra cautious with how we're treating those type of requests. Those type of requests are what we're going to see on the rise as far as litigation is concerned, where people are coming directly to us and asking for money. We had a school just at prom season, so it was just a couple weeks ago, where one of the prom kings was in a wheelchair. And so they wanted the Indiana Rotary Ballroom to build a special ramp so that he could be announced at the exact same time as all the other prom king candidates, and announced in the exact same way. They all come out at the same time, but there wasn't an appropriate wheelchair ramp for him. That's a prime issue for discrimination. Are you treating the kid in the wheelchair differently than you're treating all of the other kids? Because under the ADA, we have to treat everybody equally. It was a real simple solution. We said, we'll just announce all the kings a different way. Like, let them all be standing out there and then just bring all the queens out. Then you have no discrimination. Everybody's getting treated the exact same way. But that's a situation where it's going to be a super easy lawsuit to file because you've treated someone with a disability in a different way. And it has nothing to do with education. We're at the prom, but you're discriminating against somebody. Any questions on that? That's a little complicated.
Can I go back to the dog? I guess I don't understand the difference between, we want the service dog and that's an access issue, when we're providing a human that is going to do all those things. I guess I don't understand where the rub is there. I just want to make sure that I understand, like, why can you have a dog?
You're using common sense, which usually would work. So in that situation, the one-on-one IA, the human that would do everything for her, that was really part of FAPE. That was really what we were providing through the IEP process. They said that the dog was essentially not part of the IEP, not part of FAPE whatsoever. It got her equal access around the building at all times. If I was the school and I went back to that case again, I'd take the one-on-one IA out. I'd say, fine, have your dog. Take your dog around the school. The dog can do everything you need it to do. It's an access issue. But if the dog's gonna do all of these tasks, I don't really need to make sure that I've provided a human to do the duplicate tasks for you as well. So it's gonna be a really tricky case-by-case determination, but anytime that you have a case conference where they're requesting a service animal, we at least have to entertain the idea of, are you asking for equal access versus are you asking for something that's educationally necessary?
Where does it fall in terms of the documented disability? Because we've already dealt with a couple of these things, of people wanting to bring, they've got a therapy dog, it's not a service dog, it's a therapy dog, to help with their anxiety that it calms them down to pet the dog. And so what we've said is the dog isn't coming to school, you know, that if they get that upset, that they can go to the office, we'll call home, they can bring the dog, they can have time with the dog, or they can do it at lunchtime or whatnot. But, and again, because there's no documentation, I mean, the parents are telling us they have anxiety, you know what I mean, and maybe a counselor is telling us that, but I mean, where is, I guess, I'm sorry, that's bizarre, that makes me want to leave education just in general, but where is it that it is a violation of equal access to a disability? Like, where is their obligation to show that they have a disability? I think that's the question I'm trying to ask.
Let me comment on one thing. Jess can follow up on what I say. Remember one thing that I recall that is going to be somewhat unique for Westfield. I forget how long ago this was, 6 months ago, a year ago. We have a discussion with an outside group.
Our new facility dog.
Having a facility dog. Right. But I think when we had that conversation about the facility dog, we noted that might provide some entree opening the door for people to ask for therapy dogs. Remember that discussion we had? We had a little bit of discussion about, is it a service or comfort animal, or is it a service animal? If the facility dog with an outside group is being allowed, that could lead to other people asking for that same thing.
We're getting a ton of requests across the board for therapy and for comfort animals. That's certainly an uptick. Couple things. Number one, we're not allowed to require documentation of a disability for them to bring in an animal. Just like the post office isn't allowed to say, when you come in with a seeing eye dog, I need to see a certificate of your blindness. You know, we're under the same type of law. However, that being said, we have developed procedures that request parents to give us heads up when they plan on bringing a service animal into the school. So, for example, we can deal with potential allergies, potential asthma. We can actually figure out, how was the dog trained? Do they have any problems with specific groups of people or specific situations that might be troublesome? In general, though, I would say the more heads up you get from a parent that a service animal is coming, the more legit it seems to be that it is a service animal. A lot of these animals take 8 months to a year to train. So I actually think it's a really good thing when we hear ahead of time, I'm planning on bringing a dog in with my kid, because then to me that starts to trigger, this is a legit service animal. We can request a lot of things from the parents, and we can apply procedures equally across the board to everybody. You know, we ask everybody for documentation. We ask everybody for a heads up. But the fact is we're really limited in what we're allowed to require to try to differentiate.
So and that makes, and when you use the blind example, that makes sense. I just think we are getting so much with mental illness, and again, where does it trip over to being a disability or, you know, whatnot, with depression, anxiety, but can you ask for specific training of the animal? And can you make the distinguishing between the service animal, the therapy dog? I mean, in my mind, those are two different things, like the access for movement and helping to the bathroom and taking off a coat is providing something for somebody that, you know, can't do those things. Whereas therapy, I mean, we've got tons of kids in therapy, right, that still come to school. That isn't that 504 piece of, you know, So can you ask for training of the animal so you know that they're not just bringing in their family pet?
Not technically, you can't ask for evidence of the training. However, again, it goes back to, we can request information as part of a standardized procedure that we request of all people. The ADA really, really hampers us with what we can require from people saying they're bringing in service animals. Now, with a caveat, one, they typically tend to tip their hand the more questions you ask. So if you are approaching it in not an aggressive, we're trying to keep your animal out, but hey, we ask all parents, can you tell me a little bit more about the animal? Does it trigger any allergies? Do we get along better with men or women? Problems in the cafeteria or large crowds? What they'll start to tell you back will help tilt their hand as to whether or not it's a comfort animal or a trained service animal. If it's the family pet that they decided yesterday was a service animal, that's not a service animal. The second thing I wanted to bring up off of one of your comments was, if the parent tells you they need a comfort animal because they're so anxious, that to me is a trigger for child find. So that's the other piece that needs to always be followed up with is, if this is not a special ed kid, or if this is a special ed kid that we haven't looked at as of depression and anxiety, and we're getting a heads up that they have it, whether or not they get the animal, we have other obligations that have been triggered now.
We actually went that way because they didn't want them in, they didn't want the documentation, the testing and all that. So then it was like, well then, it isn't really impeding where they are.
Right.
So you're saying that like 10 years from now, we could have literally 100 dogs walking around the hallway here because
Can I say it depends on how long Trump's in office to that answer? I really don't know. Right now, based on the ADA, our hands are very tied with how specific of requirements we can request when a parent wants to bring in a service
if
animal.
one of those dogs bites another kid, is the school responsible or is the parents that didn't train the dog responsible?
So that's also going to be in the policy, but technically, the parent is responsible, is liable for any damage to the school, any damage to any other students, things like that. But we're also not allowed to require liability insurance for the parents either. So it's a good idea. The people who take this seriously have liability insurance on the dog, have a dog that's been trained for a year. The legitimate service animal request that you're going to get should not impede too much the educational environment. It's going to be the one-offs. It's going to be the therapy dogs, the comfort animals that we're really going to have to be very careful about. But again, it goes back to don't say no and get sued for $14 million because you didn't have equal access to the school. We have to ask questions. We have to engage in a process to make sure we're following our obligations under the ADA.
Are there things that you can hear that does make it easy to say no?
Yeah, family pets. The question was, what are like some of the triggers that demonstrates they are a comfort animal or a therapy animal you can say no to? Family pets, anything that's not a dog. So comfort monkeys, comfort parrots. I've had a comfort chicken come in. Family pets, anything that's been trained recently, like if they say, oh, we trained it last week. Or if they say, oh, I'm going to bring in documentation from my therapist. Typically speaking, the therapist will say something to the effect of therapy, comfort, emotional support, because the therapists typically know they aren't allowed to use the term service animal. So those are some of my red flags when I hear about it.
I guess my question is, does our staff feel comfortable when you're in a situation like that, where something like that's brought up and you were caught off guard, to be able to just ask those questions and then step away and reconvene the case conference at another time? Or are these people that aren't even in, that they don't even have an IEP, that they're just bringing in?
It may not be. It may be separate from the IEP case conference. And to your point, we're giving you the very literal black and white law. Jess and I joke sometimes we are very similar in our legal analysis, actually, and we come to the same result. But I think there's times, and I don't think we don't disagree on this, you might just say we need to process this request. all right? And leave that as an open-ended, we're processing it. We're not denying it, we're processing it. To allow you to hit pause button, check with central office, check with us, process it to see where we're at. Shane, y'all, some of you worked with Seamus and know Seamus in our office as well. He has one right now that I think he just recently resolved that had been going on for weeks, and there was a threat of a lawsuit, and he just kept kind of dangling the carrot out in front of them and saying, oh yeah, we're processing it, we'll get back to you. And to the extent where he was able to ask a lot of those questions and to sort through. Now, technically, on the black and white of what we've just been explaining to you, you're not allowed to do that, but if you're processing the request and you're trying to sort through the information, that's how we dealt with it.
And if we ask the same question, I'm not discriminating against you if this is the questions that we ask anybody who wants to do this. That is a good protection for the school to be able to say, this is how we process everything this way.
So yeah, I mean, if somebody shows up day one and has it, and it's the comfort monkey, and you want to say no, not say no, you want to say, well, I need to process this.
Well, we can say no to the monkey, right? Because it's not a dog, right? And the miniature horse.
Yes, the miniature horse is
That's out, right?
All right, well, sounds like that's a good topic of interest. Actually, yeah, we got. All right, so let's move on. I'm going to wrap up the special ed portion by letting you know there's several slides here. Again, actively through our office, we're working on changes to the federal reauthorization of special education law. There's lots of issues which your special education folks can tell you about when we deal with due process and everything that goes along with IDA. But the long and the short of it would be this. We're trying to work on ways to make it less contentious. 90% of the cases that we see filed are sort of an I gotcha surprise attack filing, where if you as the school district were actually made aware of the dispute or the disagreement, you may have been able to resolve it. So we're working on that to say, shouldn't there be some sort of mechanism or filter to deal with special education complaints? So again, for the purposes of time, I'm going to move through these, but there's some suggestions there, some things we're doing. Also, just interesting, sort of in the grand scheme of our nation, we're also trying to consider the fact that, there's lots of other different agencies out there that are responsible for families, or that should be responsible for families and students that need brought into this discussion about programming for mental health or programming for special education. And in fact, Mayor Cook and your youth assistance program, that is one alternative that you at least have here, is to use that program. But bringing in other agencies that should be financially responsible and not just public schools dealing with the mental health epidemic. All right, we're going to go now to custody and parental rights because this was on your list of items. This graphic and this picture kind of tells the whole story of mom and dad. I guess I would start again, now that I've got you all really active and talking this morning. What are your questions, concerns, issues that you've seen over this past school year on custody and parental rights issues? I can talk to you about some of the definitions that are in the slide, but I think we also like to dialogue with you about what concerns you've had with custody battles, with parental rights, etc. Anyone? Now, you're going to start to get called out here if you don't have a school bus in front of you. That means you haven't talked yet. So
we deal a lot with just the divorce situation, who has custody, who doesn't have custody, and mom, who's kind of the custodial parent, student lives with him, is upset because dad didn't do something. All of a sudden now, mom wants all of dad's rights taken away. You can't come to school. You can't do this, that, and the other. It just seems like some of these documents that we have are just so old, and just a lot of legal terms. It's just difficult to figure out who's right in that situation.
okay. I don't know why, but yes, we've probably, I think, over the past couple of years, seen seen an uptick, seen an increase in exactly what you're describing. And not just asking for records, but asking for your teachers, your counselors, some of you, to come into court. I would encourage you to take back a couple things to your building level and for all of you. We now have a pretty efficient, streamlined process in our office of filing objections to these subpoenas that come. The problem sometimes would be that you guys get those, and sometimes they send them to you at the building level. They don't send them to the central office. Talk to, and I don't know who the filter is at central office for those things.
They would give us like a day's notice.
Yeah,
We
well,
received one, and we
yeah.
were supposed to report the next
No,
day.
I understand, and that's where, as soon as you get it, if you receive it at the building level, get it to central office or whatever, we now have a pretty good template for filing objections to these, and we've been pretty successful. Yes, and there's asking for our fees for it too. So recovering the district paying Church, Hittle, and Antrim to file these things. There's not a lot of ways that you recoup your attorney's fees, but this is one of them. And so if they don't give enough notice, and if they're unreasonable in asking for 5 people to come in and be witnesses, we can let us know that, get it to us, and we'll get that objection filed as soon as we can.
I would also add, parent attorneys frequently use the day's notice as an intimidation tactic. We can get around all of that. So don't feel like when you get one of those subpoenas right away, oh, we've got to get to them, tomorrow. We just need to figure out how to deal with that. But that's, speaking on behalf of the legal profession, that's incredibly appropriate.
So the rationale for that, and on top of that, and maybe 3 years ago, we were able to successfully pass an Indiana code provision that says there is an increased fee amount for a school employee being called during a school day. So if you're subpoenaed as a superintendent, as a principal, as a teacher, they're supposed to pay $100 for you appearing as witness. Most of the family law attorneys still don't realize that, and so they don't send the check and they don't send the fee, and that's another reason we object, and they're able to do that. It's not as much of a speed bump as we hoped. We might have to bump that $100 up to $500 because they're often still saying, okay, well, we'll pay the $100 for 5 people to come. So we're, every now and then there is a real reason. It's usually not the custody reason, and these are just some slides with reminders on legal custody and physical custody. It's usually more of a domestic violence or child in need of services or child abuse situation at the home. That's maybe where it could be more important for us to appear. And if so, I think we want to do that. We want to be there to testify to anything that your folks may know. But, how is custody determined? There's paternity situations, there's divorce situations. The court looks at these things. The major difference that in a paternity action, the biological mother is the sole legal custody under Indiana law. And we also, I think, with our attorneys that we have in our office, our family law attorneys, there are sometimes very confusing orders. You guys have seen those. Our biggest mantra to you would be, do what's best for the kid. If you've got somebody standing in your central office, in your lobby, arguing about they're supposed to go with the dad's girlfriend or they're supposed to go with the aunt, our biggest thing is, if you feel it's not safe, if you feel it's not appropriate, hold the kid back. We don't see that a Hamilton County judge is going to fault us for making a decision like that. I mean, there have been times when we get calls in our office from you in those situations, and we'll help you interpret the order. We'll do things like that. But if you can't make that decision because it's an emergency, just go ahead and make the decision that's best, that you think is best in that situation. Why are we being drawn into these? Because the court does determine things based on the age of the student, the wishes of the student, interactions with siblings. All of these reasons are under the Indiana law for determining custody situations. So that is the rationale that some of the family law attorneys are trying to pull your records and pull some of your witnesses. But again, maybe if there's one person that has seen something or has heard a comment from a parent, or has heard a comment from a student, I think we do want to be good stewards and good protectors of the child. We do need to participate. But when we're getting these unreasonable requests, we're going to try to step in and object to those things for you. All right, why don't you take this, because this is a kind of a hypothetical that that we were just floating out there. Let's say we have a non-custodial parent who signed a permission form for an evaluation. The child has since moved to live with the other parent, who is the custodian, and parent number 2 does not agree with the request for the evaluation. It wants to rescind permission, but is okay for one area, but is okay with the evaluation in another area. So this is ED, is emotional disabled, and specific learning disability. So we've got this dispute between a non-custodial parent and a custodial parent. Which permission form stands? Thoughts?
I think it's a trick question. I'm sure I'm going to say number 2.
So go back to, we love to throw out there, it depends, but go back to that there's legal custody and there's physical custody. If that non-custodial parent has been stripped of both legal and physical custody, then, it is going to be the number 2 of the person that has the full custody, legal and physical. If there's a situation where that non-custodial parent doesn't have physical custody, but they do have legal decision-making, we may be able to go forward with their permission. And oftentimes we joke about, well, we want to choose the parent that's most, aligned with what we're trying to achieve with our school district. So these custodial parent fights, arguments about doing evaluations, these are increasing for whatever reason. I'm not sure I can explain why that is, but we have some good remedies and good people to help you guide you through this. Also keep in mind that we get some protective orders sometimes limiting a parent's access to a child. If there are protective orders in place limiting their access to records, specifically limiting a parent's access to records, that would be the time that we do not provide that. But otherwise, unless it's specifically restricted, parents, non-custodial parents as well, are allowed to have access to school records. Parents should take the initiative to obtain the information about their child. Each parent is responsible for establishing their own relationship with the child's school. So this is under the Indiana Parenting Time Guidelines that does actually encourage them to have multiple parents reaching out to the school. Now, that doesn't necessarily mean we have to schedule multiple meetings. We often will talk about if there is a disagreement between the parents, we'll have one on the phone and one come in person. Questions on some of this as we go a little bit faster? Okay, these are on your list, so I'm making sure we click through it. All right, duty to report. We are going to need to talk about a change as of July 1st. And I think Chris, Jessica, I will want your input as well as what we've been doing with policy. Reminder, not just for child abuse, but there are other areas in Indiana law that indicate we should have a reporting requirement. In fact, there is a specific Indiana code provision that says teachers or school employees that are harassed or battered or intimidated or threats are made, that there's a reporting requirement for reporting those things against our adult employees. That doesn't get highlighted or emphasized as much. The child abuse reporting statute gets more attention, but if a school employee is subject to harassment, battery, intimidation, or threats, there's actually a requirement that we're supposed to report that. Other violations of the law, criminal gang activity, besides child abuse reporting, just keep in mind that making a report to law enforcement, even though it sometimes is uncomfortable or pisses off the parent, that might be necessary. Okay. All right.
Go back to that minor alcohol consumption. So when we hear, obviously if it's in school, you contact the parent, and we usually contact Officer Daniels. But if we are made aware of a party on a Friday night and we hear that 7 or 8 kids are there, it would come to our attention, let's say, because one of the kids is an athlete and, through our athletic handbook, they have to report. Are you saying that now we have a responsibility to report that suspicion of consumption? That can't be right.
Not necessarily, no. We're gonna highlight again in just a review fashion here in a couple minutes, the bullying reporting, which would require you specifically by statute outside of school grounds to report bullying. But the minor alcohol consumption is school grounds, something that you know of, reporting to Officer Daniels, as you mentioned. There's nothing affirmative that if you hear a rumor about it happening, like the bullying law, that you would have.
What if you know it happened though? Like the party was confirmed and you have all that information.
This specific law that we're talking about is on school grounds.
Okay, is that the same thing with sex? Like, because we sometimes get kids that will tell teachers about, I had sex, I regret it, I've done whatever. But then there's always that thing between age of consent and whatnot. We had a situation like that earlier this spring that teacher just thought she was talking with the kid. She referred the kid to talk with her counselor, but then it came back that 2 years ago, this child disclosed to the teacher that she had sex and the guy was 19 and the teacher should have reported. You see what I mean? And so
Yeah.
I guess I don't even know.
So I jumped forward a couple slides to hit on that question. This isn't exactly what you're describing, but I think that we have maybe conservatively, maybe this is the wrong answer, but hearing about situations involving teen sex or that topic, we have started to probably be a little bit more slanted towards reporting. Only because if we don't know the ages, if we don't know that there's a situation where there's abuse, reporting to Officer Daniels would be fine because it is a DCS for law enforcement. But in a belts and suspenders fashion, I think we are looking at reporting knowledge of sex, sexting, those things on a more frequent basis. Now, that might, practical level, cause some relationship issue between the teacher and the student or the guidance counselor and the student, but as we hear about more and more people being prosecuted for failure to report and knowing some things, I think some of you read Tipton schools right now as an issue. That's different than just a boyfriend-girlfriend situation, but they had knowledge of something going on and now they're going to go through a whole possible prosecution. So, I don't know what that does, Stacey, on your practical level, but
I just said this scares me. You know what I mean? Just this whole new reporting thing and the obligation to report, because I don't think that if a kid is talking with a teacher, our teachers aren't trained to even go through that thought process of how old is the student? Do I need to ask how old, their partner was? Am I now supposed to ask, did you consent? Did you not consent? What is the age of consent? They write 14 and 16 in those ages there.
Well,
were you drinking? What we've kind of said is, all right, if you know that if the kid's admitted to being, drinking or drunk and then having sex, that it's important to report and just make sure their parent knows. So this just scares me to death a little bit with what we're supposed to do.
yeah, let's talk. This is a good topic, and it kind of leads into
And maybe it's not appropriate for you guys, so again, I don't mean to monopolize, but I have a feeling this is really going to impact us the next few years. So if nobody else needs to know, maybe we can talk later.
I think we need to take a minute.
I think it's really important because I think especially for our staff members to know that they don't have to interrogate, they just need to understand what their role is, because this could happen at any level where a student's talking about sex in general. So I think having some clarity for our staff on when it's necessary to report is a part of their duty.
Yeah, we're getting ready to enter into that topic a little more broadly anyway. So let's try to do that. reporting suspected child, and maybe this will flush out some of those answers, maybe not. When a staff member has reason to believe that a child is a victim of abuse or neglect, it is a crime to not report the abuse or neglect. So I think kind of like talking about what is under special education, the case we talked about, what is a free and appropriate public education, how do you define benefit? This is the definitional point that's tough. What does it mean to have reason to believe?
And guys, is child, when it comes to sex, 18 or 16 or 14?
Yeah, you mentioned a few minutes ago, depending on the age range, there's a Romeo and Juliet age range exception. I kind of forget what that is. I think it's a disparity of 2 years or 3 years between their age. But if they're 18, if they're under...
At 14, you can't consent at all. So if they're 14 or under, they're there. But after 14, should we just go with the mindset that your child till you're 18 to cover ourselves? Jenna, I guess I just get hung up on clarifying that even that first word for our kids.
On what it means to have reason to believe?
No, child.
Well, for purposes of sex, I think that might be something we can think about, you guys adopting across the district. And you described a second ago, how do we have people trained to recognize this? I mean, obviously 14 and under is a highlight. Between that 14 to 18 range, I'm not sure I have an answer for what is reason to believe when it's sex between students. Do you have any thoughts?
I would caution you from getting caught up in the age. I would caution teachers from getting caught up in the age because the law is written so broadly. Reason to believe abuse or neglect is a very broad definition. So for me personally, if I was a teacher and I was hearing about my student having sex, it's a little bit of like the ick factor. Like, I don't really care how old you technically were and when your birthday was and when the boyfriend's birthday was. Like, for me, it's, do I have a reason to believe that there's something ill going on here? Is there something that smacks of some sort of abuse or neglect? That is enough to trigger a response for me. So I really wouldn't want my teachers worrying about what the ages were. I would want them more focused on, if in doubt, report.
I guess maybe that's just what came up to bite us, was that the girl who was talking with a teacher, there's 2 or 3 layers to it, but talking with the teacher didn't think that, and it sounded consensual, it sounded like something she regretted, it sounded, whatnot. And then the girl came back and said she was raped. She had been drinking and was raped. They came back to the teacher, and the teacher's like, whoa, she didn't say any of those things. And then the boy wound up being like 5 years older, and the teacher was like, well, I mean, she didn't say any of those things. How would I have known that? So I guess that's just... Yeah,
that's a good point. And so, I mean, I know there's challenges on both sides of this equation, but I don't know how many of you, I'm just going to say what I read in the paper, but, that was the start of the Tipton Schools situation was a little bit like that, although it was an adult, that, hey, we kind of knew something was going on, we didn't know all the details. And so, in law school, we learn about, for situations involving injuries, we learn about the reasonable person test. So I tend to apply the reasonable person test to this reason to believe. Would a reasonable person hearing what your teacher heard think that there was a child abuse situation? And I suppose that will come, we've got Park Tudor, we've got IPS, we've got Tipton, we've got all these people going through this. Now, those, if you just read what you read in the paper, those seem like, oh wow, they should have done that a lot differently. But if you put yourself in that situation like what you just described, I only have this limited set of facts, why would I possibly have made a report? So this is tough, but we're gonna get even more complicated here in just about a minute when I talk about the change. But use the reasonable person test. What's what's reasonable for your local standards and your community and whether you think there should be a report. I can tell you that if I was back in teaching role or your role, I probably would want to over-report and just to have a protection of these prosecutions that are going on. So let's talk about July 1st, 2017, here in a couple weeks. You've got some changes that we've been working on with the relevant statute. Again, in addition to any other duty to report, an individual has reason to believe shall make a report. Here's the change. Some of you read about this already. Some of you sitting here already know about it. But basically, if an individual is required to make a report, you know how it used to say, and simply that they worked with you as the building principal, the person in charge, to make that report. The law now, pretty specifically, and Jess and I have had some good brainstorming on this, to make that immediate report now. So, and then after that person makes the report, they go tell you. So, it used to just talk about you have an immediate duty to report. It kind of allows you to do that as an individual with the principal. Now we're talking about if your teacher's having that conversation in the hallway and something rises to the level of giving them the reason to believe, let's change your facts a little bit, and then they get some additional information about the kid being 5 years older, that teacher is supposed to make an immediate report. What do you define as immediate report? Well, we know there's at least one case in Indiana that says a student being sat down for 2 hours while an investigation took place of whether she was raped, that was too long. 2 hours was too long. And so, there's the provision of reason to believe, there's the provision of making the immediate report, and now there's the language change that talks about after making the report, the individual should notify you. When I first sat down and read this, I had quite a bit of heartburn. We discussed this at our annual school law seminar that we did right after the legislative session, that it really is important, I think, as you as the building leader to know whether a child abuse report has been made. Well, that throws this off a little bit. So actually I would like you to talk about that, and as we introduce some suggestions, and Jessica, you want to take over that piece, what are we going to try to do with the procedures to do that?
So we have updated the procedures for child abuse and neglect reporting. And not only to reflect the new law, but also, I think in our estimation, to provide more detail to you, to your staffs, to know exactly what to do in that situation. So the first part of the new procedure does reflect the new law. It says that if an employee has reason to believe that a child is a victim of abuse or neglect, the employee shall make an immediate report to DCS. Here's our key phrase. Ideally, this report will be made in the presence of the child's building level administrator or counselor.
Can I stop on that for 1 second? Back to the immediately piece that we just emphasized that 2 hours was too long. I don't think I have a problem with your teacher hearing that information, reason to believe, I need to make a report, walking them down to your office and doing it with you. So 5 minutes passes. I don't think I have a problem with that. I think the longer we go in doing that, 2 hours, whatever, we're going to run into that situation where the case said that was too long. And I think that the pitfall that many of you get in, and I've seen this happen, not necessarily here, but other schools, is that you have a desire to do more investigation. And that's where really this statute and the cases that we've seen are telling us, don't do the investigation, let somebody else do that. Let your law enforcement or DCS do the actual investigation. But you are supposed to just, if you have the reason to believe, make the report. Now, I know in some situations that may be against a fellow coworker, or it may be against a parent that you really like. But we have to be able to explain we're we're restricted by this. So Jessica came up with this suggestion in your procedures that ideally we are still going to have that person making it along with you. It's very conceivable though, you're out of the office and they're not able to do that.
Or it's a coach after practice at 9:30 at night.
Which is also why we wrote this so broadly. We wanted to, a lot of schools have like, you need to ideally make this with your principal. We wrote this with Dr. Gray, Kim, Chris, a little bit more broadly to say any building level administrator or counselor. So that a teacher or a coach, could, like Chris said, could easily find somebody. Somebody is going to be available to sit with you and make that call. Now, if you immediately can't find someone, every administrator and counselor is out of your building. Well, we probably have another problem at that point. But if they are all out of your building, the employee still has to make that report, and then immediately thereafter would notify the administration or the counselor that that report was made. So again, not delaying it to try to find somebody, not delaying it to try to investigate, but ideally keeping your building level administration in the loop of what's going on and what you're reporting.
Could it be the case that Stacy said it's after hours, they find out, they make a quick phone call to Stacy. If they can't get her and then call, but if they can't get a hold of somebody, they have to immediately make the report. Would that kind of work? That's why I would say.
Yeah, exactly.
But if they can't get a hold of you, they can't wait. They're just gonna have to do it.
Yeah. Coach calls, you can't get to you. Coach calls DCS, makes the report, sends you an immediate email and says, I just had to make this report, touch base with me first thing in the morning, that kind of situation. We added some detail in the procedures about what is needed when they call DCS. Again, this is just trying to help employees get a grip about all of the things that DCS is going to ask them when they get on the phone with them. So it's things like, are there weapons in the home or what's going on in the home, that kind of thing. You probably won't have a lot of answers for all of those, but it just helps employees kind of get a grip around, here's all the things DCS is going to ask me. So it takes away a little bit of the mystery of that call. If DCS can't be reached, we'll contact local law enforcement immediately. The law provides for us to contact either one of them, but DCS is a 24/7 hotline. It's a lot easier to get to them. The building administrator could decide to notify both DCS and law enforcement simultaneously if the situation called for that.
Now, one thing on that, and we're going to get to talking about employee interviews or guaranteed criminal acts by employees. There are times when I've heard from law enforcement, if it's a teacher, student, or employee, student abuse, sex relationship, they sometimes law enforcement wants to be contacted as well or immediately, just because they may be the ones to do more of the investigation than DCS.
I know with ours we talked about, I know a lot of you share it with Kim or with Tyler, they can start their sometimes they don't hear from DCS for a certain period of time. And that's frustrating for them because they could have maybe done some investigating or something that needed to be more timely, So I know you guys, a lot of you, I think it's been our practice to share with law enforcement as well. It's kind of the relationship we have. It's worked out pretty well to do that. And they can decide what to do with it. But they've just been frustrated not knowing, and they could have maybe got some information as opposed to time going and parents or kids covering up or changing stories or things like that.
And like our SRO, Tyler will ask if we can get the case number from the DCS. That helps them with the investigation.
I think two of the key places we've seen that are any type of sexting, sextortion, child pornography kind of being put around on the phones. That's something where DCS might take a while to get to it. Law enforcement is going to immediately isolate the phone. They're going to be able to preserve that evidence. And the other one, of course, that comes up is the Muncie case from 2 years ago, where there was the alleged rape at the school building. Calling DCS for that, of course, is appropriate, and they got in trouble for waiting. But the other piece of that is you've got the rape that happened in the bathroom, the school bathroom. You've got evidence there that's going to be spoiled very quickly. So that's where bringing in law enforcement to be able to preserve a crime scene really is super important.
Can I ask you a quick question? In regards to staff members, we had a situation this year where we had a student say something that the staff member did something inappropriate. I was really caught in the, do you go, I mean, we called CPS, but then somebody said, well, shouldn't you go, I mean, they're gonna come and talk to the staff member, shouldn't you go tell the staff member? I didn't feel like that was, there was no part of me that thought this was true, and it was not. But I still felt like legally, you don't go tell the staff person, you know.
I think, what comes to my mind there is law enforcement being upset that we did that, because it doesn't allow them to preserve cell phone or, information. So,
That one, probably didn't even contact the police on that one, probably.
Well, we did.
Called DCS for sure.
We called DCS for sure, and then we called Tyler.
Just let that know.
Yeah.
I have another question. So with the reporting, if a staff member comes, they are the one that reports, administration can't report with them? Like as far as, so like a lot of times we'll have DCS that'll call us back, ask for more information, updates, and I just think of the impact that that would have if it's calling back into the classroom 2 to 3 times in a week or something like that.
That's a fair point, but I think the emphasis here is the immediately, and, I don't think at least in Hamilton County, that our prosecutor's gonna get caught up on, well, it technically should have been the teacher versus the principal. I think we're gonna get scrutinized more on, did we make an immediate report?
Okay.
I think the other thing you can tell DCS is, hey, I'm your contact person. Anytime you need to talk, maybe the counselor has more information or something like that, call me. I'll ask the counselor or teacher to come down to my office. We'll all talk together. But I don't want you calling directly into a classroom. And I think DCS will be very cooperative with that.
I just have a quick question, it might be more for Chris. When these new policies go out, are they going to instructional assistants as well?
Oh, yeah, they go there.
Because I was going to say, they, in the past, have been probably.
Yeah, they had them last year. Safe Schools is every employee in the district.
Yeah. But this particular, okay.
Yeah, now we'll do this one isn't just gonna be it'll be sent out, but we need to talk as a group. This is something we'll talk, you'll need to emphasize at your start of this, your meeting. We've talked, I think it's one that's gonna have to be emphasized at your first meeting at the beginning. You hate to talk about a lot of those things, but I think it's something we're just gonna have to, it'll not only be sent out, they'll sign off on it, and I'll send something too to notify them of the changes and updates. But this is more of a conversation that we need to have just with our staff members here at the start of the school year, that first meeting, to say, this is how it's changed, it's not our choice, this is what's required by law, so this is how it's going to work going forward. Does that make sense? Just cover that. I can see this as being the main policy that we just review and make sure they're clear, and we're there to support them with this too. I do appreciate, it's the massaging of it still works that they can come down and talk to you, just has to be immediate right away. And I think that's going to happen in 99.9% of the cases, somebody's going to be available. But just knowing that if you're not, that we understand you need to make that decision, and when in doubt, call, and we're going to support you in that call, no matter what. We're going to be backing you. We just may not be there when you're making a phone call. You let us know right after, and then we'll follow up with you and support you in that way, if that makes sense.
Can I ask another question about abuse towards staff? So, and I may be getting in a rabbit hole here, but like with severe and profound classrooms, life skills classrooms, when staff members are injured and we complete, what's it called when we send you med check, workman's comp, because there's evidence that a kid injured a staff member by physically, if you use the word battery against them, do we have to report that?
So I'm just going to go over the law really quickly. The law says you have to report harassment, threats, battery, or intimidation. This law has been around for a very long time, and it's not frequently used at all. In a profound needs classroom, that does happen all the time, and sometimes it could rise to the level of battery. I think it's going to be on a case-by-case basis that you make that analysis. If it's a student who frequently has behavior outbursts, And we frequently are putting them in holes, and this was just a freak hole that, a punch landed and somehow a teacher got caught. That to me is very different than a student saying, I'm going to kill you, and lashing out to batter a teacher. So I would really determine that depending on the student, depending on the teacher, the IA, it would be a case by case for me.
But so the verbal threat of hurting somebody or killing them or blowing up the school, if there's not, if it's pretty common that it happens and there's not lashing out, that doesn't need to be correct.
Technically under the law, yes. Practically,
Every
no,
day.
it happens every day. I mean, I was in a special ed classroom, I can't tell you how many threats I got.
Right.
And I'm still standing. So, yes, under the law, technically, those threats do need to be reported, but like I said, the law's been around for a really long time, and it's really a case-by-case scenario. It's the kids who you don't expect it from that really scare you. That's when I'm like, okay, I need to make sure somebody else knows about this. That's when I'm gonna report it. Okay, I'm gonna speed through the rest of this procedure. We already talked about don't delay reporting in order to investigate the veracity of the suspected abuse or neglect. You automatically talked about, especially for a kid who doesn't always have a great relationship with the truth, we can't question that. We can't question the veracity and investigate whether or not there's something that corroborates that. We're gonna immediately report it no matter what. The last couple pieces here are exceptional circumstances where employees and building level should make sure they contact central office. So number one, if you suspect that they're being abused in the home, and if you release them at the end of the day to the home, you're jeopardizing their safety, contact central office, let's talk with DCS and law enforcement, let's figure out how to put them on the bus or not put them on the bus. But like Andrew said earlier, always err in the way of, I'm going to have caution for the student's safety. If I choose to not put that kid on the bus, because I'm sure there's a pretty good chance they're going to get beat at home, and I just found out about it at the end of the day, a judge is going to back you up. We're always going to err on the side of caution for our students. Also, if a law enforcement officer or DCS comes to the school and asks for the student to come with them, or asks to interview the student while they're at school, contact central office. Make sure we've gone through the proper procedures there. Don't just automatically, because they're in a uniform, sometimes, especially front office staff, they come in a uniform and they say, I'm gonna talk to the student right now. We need to press the pause button and say, okay, let me contact some other people, let me make sure that this is all copacetic. We have a subpoena or some sort of evidence that you need to pull them out of the school day to do this. And then the last piece of the
sorry. Can you go back to that one? I just want to make sure I'm clear. Is this only when abuse has been, like neglect and abuse? Because we do have an agreement with Westville Police that they will come in and question our kids on other things during the school day. So is this only with abuse and neglect, or are we just in that one realm here?
So you have an MOU with Westville Police. You also have another policy that we just made on government agencies coming into the building and when we're going to let them see our kids or not. Generally speaking, with abuse and neglect, if the courts can see that they are investigating abuse or neglect in the home, then they will typically let you interview the kids at school. Sometimes they even let you pull the kids out of school to interview them. That's very specific to just abuse and neglect.
Oh, okay, I just want to make sure that with the law enforcement piece.
We held off, we have the MOU, we actually have a small edit we're going to make to the MOU. I think we were waiting to see kind of what changes we made with your policy. I don't know that anything with your policy will change the MOU.
And then the last piece here is if you're conducting a different investigation. So if, for example, you're doing an investigation under the anti-bullying policy or the non-discrimination policy, and all of a sudden we find out that there's also abuse at home going on, basically in that situation, we need to make sure that we're communicating with DCS to finish up our investigation at the school level while not interfering with DCS or law enforcement's investigation. But sometimes we get tripped up because DCS gets involved and then the school's investigation gets dropped. we have to make sure we still have that active obligation to continue our investigation while simultaneously working with the abuse or neglect investigation. Okay, that is all your changes to the child abuse procedures.
Okay, I'm gonna actually hit a couple of our final topics. It's interesting, we always try to gauge our time. I would have never thought we would hit 3 hours, but we're just about there. So let me try to get a couple of the final topics. And if we have to end up holding some more of this for another time or for your reading pleasure, we can do that. We've talked before in Westfield, and over the last couple of years, you have had at different levels transgender students and families coming in. So there is an update, though, to one recent case, and I'll forward you to the slides to go to this slide right here. Transgender boy using, and by the way, we should all know the vocabulary now. What's a transgender boy?
Born male, raise your hand. Born female, raise your hand. Right.
Good. Correct. Still a little hesitant, but you know. Born female, so a transgender boy using the boys' restroom for 6 months without incident or complaint. Teacher saw the student washing his hands in boys' restroom and complained to administrators. School gave student option to use the gender-neutral restroom in the main office or using the girls' restroom. So, changing pronouns, changing student records, even bathroom, I think has become a little bit easier to manage. This court decision said basically that in the Seventh Circuit, including Indiana, we uniformly agree that the frequently raised and hypothetical concerns about a policy that permits students to use a bathroom and the disruption that's going to come with that, we just don't see that those have materialized. That's what the court is saying. So the transgender boy using the boys' restroom, the court is saying, we don't see that that's really caused issues. And for that reason, they determined that the privacy arguments of other people and they're leaning towards protection for restroom use. And this was very fact specific. It was a restroom scenario. So that is recent. This Wisconsin decision and telling us that there are concerns about telling a student they can only use the gender neutral or girls restroom if it's a transgender boy. I think for the last year we've kind of known that. We've been doing things to help work through those situations. For me, I'm going to still fast forward to one consideration here. Under bathroom and locker room use, it says consider the Kenosha 7th Circuit, question mark, question mark, question mark. I still see that as a little bit of an open issue in general, is more of the locker room. We've got a variety of cases happening across the United States to discuss access. We know that right now, the 7th Circuit, including Indiana, is telling us that concerns about privacy or concerns about disruption or concerns about things that the public has, those aren't valid for purposes of restricting restroom use. I still think there probably is a separate analysis that's going to come for locker room and showers and things of that nature. I mean, I keep hearing from all sorts of people that nobody showers anymore anyway, but that probably still is a little bit of a remaining issue on transgender. But that's your quick update. Jessica, anything there on that topic?
We have some slides for you to peruse in your free time about what to do when you're approached by a student or a parent who wants to make a transition. I always remind everyone that transition in the transgender world is a long process. And so depending on where the student's at in that process, you may have very different ways of reacting. But it always goes back to interactive process. We're meeting, we're sitting down, we're talking with you. We're never going to tell you no to an accommodation unless we've talked it out and tried to find alternatives that everybody can be happy with. But, like Andrew said, I think a couple years ago, we would have definitely aimed towards, go gender neutral, go to the nurse's office for the bathroom. Just make sure that you're using an individual stall, something like that. And we're seeing the winds shift a little bit, especially because we're seeing that in a lot of these cases, it's not the students that have a problem with the transgender person in the bathroom or locker room, it's the parents. And the courts are starting to say, we don't really care what the parents think. It's really, if it's not a disruption to the students, if it's not disrupting the educational environment, then let them use the bathroom they want. But we're going to see shifts on this. We're going to see a Supreme Court case at some point, and we should hopefully get better guidance.
Okay. Let's go to, let's advance forward. Questions on that? Some of that, you've read the news, shouldn't be a surprise.
Andrew,
Yes, sir.
let's say there is a disruption, okay? We do have a transgender boy, girl, whatever, and there are students that are upset about it. Does that change the conversation then? Or is that, no, get over it because the judges tell us no one else is upset about it?
I don't think being upset about it changes the conversation. I think that's already the case. But I suppose we talk about fights, or we talk about bullying, or we talk about something like that, then it's probably going to turn to a bullying analysis and what we're doing to protect the students.
So those students that are upset, it's more of a conversation, hey, you guys are going to have to get over it. It is what it is now. Or are we saying that that's causing a disruption? The transgender student now has to change what they have or have.
Yeah, I mean, I didn't dive into the full analysis, but part of the analysis of this court decision and also some other decisions in our state in Seventh Circuit are basically saying that sex, gender is going to fall under an analysis for equal protection, and meaning that transgender student, transgender employee has equal rights to bathrooms. And I think that is what we're seeing forecasted. Now, I'm not sure yet on whether that is the same. Maybe I'm wrong, but there might be a distinction drawn there on locker room and changing, but I think that still remains to be seen.
The number one area you're going to get hit up for is discrimination. And asking the transgender student to be treated differently or to change their ways is always going to look like discrimination to a court. So you're always safer with trying to have a conversation with the students that are upset, maybe bringing in an outside group, an advocate to have a dialogue about it. But it's always going to throw up a red flag to a court if you're changing what the transgender kids do.
Okay. That transitions. The two slides I'm going to highlight for bullying, keep in mind that there are lots of different perceptions still. And when we first started our roadshow of presenting on bullying a few years ago, we had the same slide. But that continues to be an issue that the more it's made its way into our vocabulary, I do see a little bit of us as the school people, employees, teachers, administration, adopting that everything is bullying. And I just encourage you to go back to our policies and our investigative process. Some of that is laid out here in our slides, but sometimes there is a determination by an investigator that something is bullying. But if you can remind staff that we just don't want to toss around that vocabulary, because it does now have some legal significance if we call something bullying. Let it go through the process, let it go through the procedures, let our investigator determine, and it's okay if our investigator determines that something is bullying. You've heard us talk before, as long as we're investigating it and responding to it. But my caution is I continue to see that expansion. We see that expansion. I mean, we've got a lawsuit in Washington Township right now that because the word bullying was used so frequently, the parent is suing and saying, oh, look, everybody in the school district said there was bullying, and nothing was ever done about it. So reminders in the slides here are simply to allow your process to take shape. Let the bullying process determine whether there is bullying or not. We know that there's reporting to the Department of Education, and we do that by July 1st of each here on what your bullying incident reports were. So that's another reason that it's significant to let our investigator who's doing the review determine whether it was actually bullying. All right, I'm going to get us through down to, actually, Jess, I think we're going to wrap up. I know we wanted to talk about
Andrew, if you want to talk about that with me,
Gary and Weingarten.
if we just, I can share it with them at our next meeting.
Yeah, the 10-second version is Weingarten reminding us that we allow people, when they're under a possibility of having disciplinary action, Chris is going to work to phrase how we let the association know when are they allowed to bring somebody with them.
And I guess the main question I had, just to be clear, is do we have to, when we have an investigation, if they ask for representation during that, we would allow it, but do we have to, as administrator, do we have to what's the burden of us to let them know they're allowed? I guess that makes sense. Are we required to let them know, or is it on their end to ask for it, or is it best?
The most common phrase I hear is, we're going to have a meeting next week about your performance, and you are allowed to bring somebody with you as your representative.
So that's just best practice to do that. Okay. And we'll talk about that more, but okay.
And then Gary is a companion case, actually, that talks about us giving warnings when we're interviewing somebody that may be criminal in nature. Usually that's theft or student-to-teacher relationship. But I mentioned to Chris earlier, honestly, we try not to give the Gary notice because we want law enforcement to be the one doing that interview. If there's something criminal, I don't want to give them the ability. It's basically, if you watch movies and TV, the Miranda warning, you have the right to remain silent. That's basically what it is that we're giving as an employer to the employee, telling them that anything they tell us cannot be used against them. Well, I don't really want to do that. If the law enforcement and prosecutors need to hear from them, I don't want to give them immunity to anything they tell us. Does that make sense? So Garrity is required when you're doing an interview that may be something that leads to a criminal under disclosure. But I often defer the law enforcement do that.
And you guys, with the process, contact me and we can work through that.
Okay. I think Dr. Gray and Kim, we made it through most of our topics. The last one that was on my checklist, I think, was gaming. Do you want to frame up what that was about? You want me to do that?
Yeah, well, just a little bit of background is just, there are a lot of different fundraising forms that come in that are taking place, and I just wanted some clarity for administrators on what is gaming, who can game, what does gaming look like, who can have that license for charity gaming, and then where do those funds have to be deposited if we're doing those kinds of activities. So there were just a lot of inconsistencies with fundraising forms that came in this year, and I wanted us to be able to kind of all be on the same page with who really has a gaming license, who can use it, where do the monies have to go, and so forth.
And, I know we've had some discussion too over time about, use of your facilities. I think you've kind of got a good handle on use of your facilities. But there are a couple of slides here that define that if it's some sort of game of skill that you don't necessarily have to have the gaming license, and it defines what is a game of skill, something that is enhanced through abilities, through training, like sporting events, golf, horseshoes. That's not considered a gaming license. But when there's more of a gambling in nature, like a a lottery, let me see if there's an example here. Like a lottery, a 50-50, those types of things, when a prize is going to be dispensed, that the organization itself, whatever it is, and that would be the organization that has to get the license, is required to do that when there's a game of chance or something that's being raffled. There are some threshold amounts for that gaming license, and those are also included in the slides. But the significant factor is when there's something like a lottery, 50-50, something that's being given away that's it's gambling in nature. There's some information here that's given on how to obtain a gaming license. And it's probably overlooked, but you will start to see that it's going to be enforced. And again, I think it needs to be emphasized that it should be for the organization that's doing the activity and doing the event.
So like PTOs, right? We talked a little bit like like PTOs or athletic boosters, band boosters. I think those are maybe where we see some of these different things. So do we, I guess, just knowing, do all of our PTOs have a gaming license? Does our band boosters, do these different groups have a gaming license?
Yeah, so I don't, remind me, your PTOs are set up, are they set up independently? So, I mean, encouraging them that because they are the entity that's doing it, they're the entity that's receiving the funds, they're the entity that's putting it on, they should be the one getting the gaming license.
So same thing, is that then the same thing for like our band boosters or athletic boosters? And then, so those shouldn't be, and then those funds, is my understanding that those funds have to also be deposited into those accounts? Those can't be then deposited into a school account?
Right, now they're separate as well, right? Shake your head, right? Yeah, so they should be getting their own, doing their own fundraising and their own gaming license and their own accountability for the funds.
And is the other part to that too, then do they have to designate what those funds will be used for? Is that another piece of this? Or just for some clarity? I was thinking there was something that went along, so like if you said you're gonna do a chuck it up activity, game or whatever, then these funds are gonna go into this account and is chuck it up?
Jessica was asking.
Oh, it is a thing. It is a thing. Chuck it up. You throw these ducks into like these little swimming pools. And it's a game of skill. It is a game of skill. And a very fun game. I think we should all play.
The real question, are they live ducks?
They are not like that. So there are those little ones that I think they're like little rubber ducks.
So, here's the threshold amounts.
We just want to be legit. I guess that's the.
Yeah, I mean, I would encourage that anybody that is sort of a qualified, separate organization needs to be doing this, needs to be going to the website. It's not hard to do, but they need to do it in advance of the event. And, I don't know exactly about the spending portion, Dr. Gray, on them having stipulations on where they spend it, but I do know that the accountability for where the funds go to, it's going to be tracked to the license that's obtained.
So I have a question, because Bill, you sent one in for the soccer, the girls soccer team. And you said WABC would be the umbrella, but the girls soccer team was going to have a 50-50. So when they have the 50-50, what happens to that?
We took the money, we gave half the money to the parent standing there at the game.
And then the girls'
And then the girls'
soccer
soccer team kept the other half to
But
pay
all of it should
for.
have gone back to WABC because they had the license.
Whoever the organization is organizing the activity should have the money.
So they're gonna have to deposit those dollars into the booster club, and the booster club would then write a check.
Yeah, and that might go to
I think
your,
that's what happened with the 50%. I mean, the parent who won the 50%, we handed them the cash that night.
But that's what I'm saying, I think it all has to go back to the booster.
And then the booster writes the check to the parent.
Is that right?
yeah, I mean, if the gaming license is under the booster, it's going to have to go back to the booster. Whoever the entity is that's got the license and is putting on the event.
The 50% that was won by the parents.
Yeah, that's the prize.
Okay.
Now, to your point on how you're distributing it, let me follow up with you about if the booster takes all the money, can they give then some to the soccer? I think that's part of your question as well.
Yeah, just making sure that the flow of
The
all of
accounting
the
is-
dollars is,
Yeah.
so that the Wiz State Board of Accounts, because we just know that Wiz State Board of Accounts, those extracurricular accounts are the ones that sometimes are the most challenging to keep straight, and so we just want to make sure that we're doing that. And they don't get as audited as frequently as school districts.
Okay.
The way our booster club is set up, and has been set up for years, is the booster club is the umbrella organization. Each sport has its own outline. So for baseball, there's a dugout club. For the football, there's a gridiron club. It all goes back into the ABC, the booster club, and then it's accounted to that score it's on. So it does all go back to the booster club as a whole.
So my question would be then, does, say if it's football, if those dollars, gambling dollars went into the Gridiron Club, is that the booster club still, or does it have to go to
Yeah,
the
so,
top booster club and then they funnel it back to the Gridiron?
yeah, I understand. So I think I need to, my point earlier was if somebody's putting on the, what did you call it, the chuck it up? If somebody's putting on the chuck it
I
up,
think we should try it.
then that needs to be under the booster club because they're the ones doing it and their gaming license. Let me follow up with you because I think this secondary question is, if the booster gets all that money, how are they restricted on how they distribute that money? So let me follow up with you on that. We made it through most. I know there was the one thing from yesterday, at least in your policy, that we didn't get into the slide that we promised you, which was there is a new bill, law, that says if you have a student that is permitted or is excused for an educationally non-classroom activity, the student may not be reported as absent. That's the one I think you guys talked about yesterday. And did that make it into your policy?
So we're not putting that in policy, but we are talking about putting in student handbooks for later. Essentially, it's an updated law that says if you have pre-approved a student to be absent for, what is that? If you have, it's the chuck it up. If you have pre-approved a student to be absent for an educational activity that's not in the classroom. So let's say parents are taking student to Spain for a week and they're going to speak Spanish the whole time and it's super educational. We're going to learn history and architecture. And I'm making this up based on what I wish my parents would have done for me in high school. And you approved that as a district for an educational activity, then when that student is gone on that trip to Spain, you're going to count them present. You're going to count them like they're sitting in the classroom. You're not allowed to count them absent. That's only if you pre-approved it ahead of time. And there's a list of factors that go along with that, how you approved it, because you think that there is some educational benefit to whatever they're doing outside of the classroom. But that is an update to the law because they are concerned that kids are getting counted absent after the district has already told them they are allowed to be absent.
My first question always when I see a bill like this is, who's the lobbying group that advocated for this bill or this language? But, all right, in 3 hours or less, we've got about 3 years of school law. So, questions or other follow-up to what we've gone over here this morning? Yes, sir.
Just one quick on the transgender. We've already met with the student, say in 7th grade, we need to meet with them again in 8th grade. Is that, because I know on your form it said to meet how long?
You aren't required, if you met with them in 7th grade, you aren't required to meet with them in 8th grade. I think it's a good idea to like put an annual kind of check-in, even if like the counselor's just checking in with them, to say, hey, we're starting off the new school year, how are you feeling, anything you want to change about the plan that we kind of had in place last year, anything you want to discuss with me. Let me remind you about our non-discrimination policies, let me remind you that you can come talk to us at any time, if you have any problems, that kind of thing. It's not a requirement, it's just a best practice.
Dr. Gray?
I would just say, kind of go back to one of the comments that Ryan made earlier just about our forms. So as we're going through policies and AGs, it makes me wonder if maybe we also need to go back and look at how our forms that we're using align with our policies. I don't know, that's just a wondering. I know just everyone else, I don't know if you have other concerns with forms that we use or.
You're starting to use your guidelines more, you're starting to use your forms more, you're starting to use things like that. So, part of our rationale or our motivation here was that sometimes your policies get outdated, and it was helpful to refresh those.
1982, I think, was yesterday. There was one. I think there was some of these. There was
Or 75.
Or 75.
You got rid of that.
Yeah, some we've been able to eliminate.
There's this exercise, and I think, yeah, now that we've done that, going back and looking at how to make it consistent. Anyone else? All right, again, this is one of our favorite formats. Thank you for letting us join you this morning, and we'll look forward to talking to you again on some future issues. Thank you.